Hello. So today we'll be talking about the common word bilaterals, but in the real sense, it actually refers to bilateral contracts. As the name implies, bilateral is the opposite of unilateral, and unilateral implies that it's just one-sided, while bilateral gives the impression that it's between two people. Even though unilateral contracts are not very common, they are quite restrictive because they just apply in very restrictive or very restricted situations. While bilateral contracts are contracts that form the bulk of commercial transactions. So most commercial transactions that we see in everyday life are usually bilateral contracts, because most commercial transactions that go on in the commercial world and business world are usually bilateral contracts. Now, like I said earlier, bilateral contracts are more common because you see them more in the business world. And this is because of the nature of bilateral contracts. Because a bilateral contract is a contract where the two parties make promises. So one makes a promise or an offer, and then the other party makes a counter promise or acceptance. For example, in a lease agreement, a tenancy agreement, the landlord promises and offers his house or apartment for rent, and the tenant now makes a counter promise to pay for it. So the landlord has offered it and is requesting for an amount of money to be paid as rent, while the tenant makes a counter promise. So you see, both parties have made promises to each other. So that makes it a bilateral contract. But in a unilateral contract, one person makes a promise and the other person will just carry out the performance. So the person doesn't have to make a counter promise. The contract is sealed upon the other party performing the action. A major example of this is a reward for returning a lost item. So if you put a reward and say, okay, if you return this lost item, we will pay you X amount of money. The person just returns the lost item. The person didn't make any counter promise, but the person has just accepted the promise that the promisor has made by just performing the action. So in that case, it's a unilateral contract. And that is why in a unilateral contract, the party that makes the promise, we can cancel only before the person has performed it. Unlike in a bilateral contract where you make a promise to give somebody your house at a fee for a rent, and then the tenant now packs in and pays, or pays and packs in. The landlord cannot just come at any time and just remove the tenant unilaterally, except if he follows due process according to law. And to form a bilateral contract, there are key essential elements that must be in place. The essential elements that make a contract valid are the same essential elements that are needed before a bilateral contract can be formed. And the first is offer and acceptance. So like I said from the description, when I try to describe how bilateral contracts are, so there must be an offer made. One party has made an offer, a promise, and then the other party now accepts by making a counter promise. So this is not acceptance by conduct like in unilateral contracts. This is acceptance with a counter promise. The second essential element before a bilateral contract can be formed is the intention to create legal relations. It means that at the time when they were making the offer and acceptance, that they had the intention of creating a legal relationship. That means the parties would have intended that that relationship that they're entering into is a legal one. They cannot be intending otherwise, because contracts are governed by law. So there must be no mistake, or that there cannot be an incidence of one being misled, or there was a misrepresentation of facts. The parties must know fully well that they intended to create a legal relationship by that offer and acceptance. The third essential element before a bilateral contract can be formed is consideration. And consideration means what each party is taking in that relationship. So the two examples that we have used so far, the landlord is taking his house. It is his own house. He's the one that has the house, the one that built it, and is the one that owns it. And then he's taking it up, he's giving it up for the tenant. And then the tenant is also parting with his money. So both parties have something that they are going to lose, or they are going to give up based on that relationship. So the consideration is something of value that both parties are bringing to the table. That is why, again, it's a bilateral contract. The fourth essential element before a bilateral contract can be formed is that the parties must have the capacity to contract. Now, capacity has to do with the age of the persons contracting. So you can't be entering into a contract with a minor, that is an underaged person. That person cannot take responsibility for him or herself. So that is why you can't get into a contract with a minor. But then there are exceptions to the rule. Also, you can't also be contracting with somebody that is of unsound mind. So this means that you cannot form a bilateral contract when the purpose and the terms of the contract are based on something that is illegal or unlawful. And this is clear because the law cannot aid you to enter into a contract in something that the law speaks against. So before a bilateral contract is formed, the purpose and the terms of the bilateral contract have to be legal. And these are the key elements before a bilateral contract can be legally formed. And the bilateral contract can be binding and enforceable in Nigeria. So each of these 5 elements have to be present. It's not if one of them or 4 of them are there and one is not there, the contract will not still be valid. So for your bilateral contract to be formed and be validly enforceable, these 5 conditions, these 5 elements have to be present. We'll now look at more specific examples of bilateral contracts. First on the list is a sale of goods contract. Again, like I said earlier, this is like a supply agreement where one party undertakes to deliver goods and the receiving party, the other party, undertakes to pay for the goods upon delivery. Another type of bilateral contracts are employment contracts. In employment contracts, the employer undertakes to pay the employee for his services, while the employee undertakes to perform the assigned roles and tasks. So typically, again, you see that both parties have promises that they have made and both parties have obligations to keep. So while the employer pays the employee for the work he does, for the services he renders, the employee is tasked to do those things. So that is why even the labor law frowns at where a worker is employed and is not given anything to do, because it is the duty of the employer to give work to the employee. So you can't just employ somebody and make the person redundant. It's against the labor law. Another example of bilateral contracts, which I've already referred to earlier in this video, is a tenancy relationship. And like I said then, the landlord has undertaken or promised to let the house, his premises, to the tenant, and the tenant also counter promises to pay for the use of the premises for a stipulated time. The last example of bilateral contracts that we'll be looking at now is the one based on service agreements. So in service agreements, the contractor offers to render a service while the client undertakes to pay a fee for the services. Now, service agreements also applies in relationships that are similar to employment contracts, but in this case, you are not strictly an employee of the employer, but you are just hired to render your services. Service agreements include the kind of services that we as lawyers render. So professionals usually, they render services where the client is now expected to pay for the fees. So we are being retained or hired to perform services or to render services at a fee, while the client undertakes or promises to pay for the services that we have rendered. Recall that I said earlier that bilateral contracts, if they have been validly entered into following all the essential elements, they are enforceable and binding. So this means that where one of the parties to a bilateral agreement has failed or breached his own side of the contract, the innocent party can claim remedies in court against the defaulting party. At this point, I will refer you to the video that I made earlier on contracts. However, I'll just summarize that the legal remedies available to an innocent party include damages, which is monetary compensation, to restore the innocent party to the position that it would have been if the defaulting party had not defaulted. So that's one of the remedies, damages, which is monetary compensation. The second remedy available to an innocent party who has suffered from a breach of a bilateral contract is an order of specific performance. And as the name implies, specific performance is that the court will order the defaulting party to specifically perform his or her obligations as agreed. And this is ordered where damages will not be adequate. For instance, in the sale of land transaction, because land appreciates, if the innocent party had paid 5 million to buy this piece of property in this location, and the land has appreciated, and somehow the defaulting party did not give the land to the innocent party, and now it is established that 5 million naira can no longer buy that land in that same place, the court will still order that defaulting party to provide the land as specifically required by the innocent party. So it's in those kind of cases where the court will order specific performance, that the defaulting party should perform the exact requirements as agreed in the contract. That is because monetary compensation in form of damages will not be adequate in those kind of instances. Another major remedy that is available for an innocent party that has suffered from a breach of a bilateral contract is that the court can order rescission. And rescission, as the name implies, is that the court has rescinded the agreement. So that means the court has upturned the agreement, taking the parties to where they were before they entered into the agreement. And the court can only grant this. And the court can only grant this order based on the performance of both parties' obligations. So there's a point where the parties would have gone to and the court can no longer order a rescission. And this is usually where the parties have already almost completed the tasks and performed their obligations. If they have gone to a great extent, the court can no longer be given an order of rescission. So rescission can be granted probably usually at the beginning stages where the parties have not fully commenced their obligations and one party has already defaulted. So the innocent party can now go to court and ask for an order of rescission so that the court should just cancel the agreement and restore the parties to the position as they were before they started, as much as is possible. And the essence of an order of rescission is that even the innocent party will no longer be held liable to perform his own side of the obligation. So that is why this order of rescission is important. So in summary, these are the legal remedies available to an innocent party where it suffers a breach of a bilateral contract. In conclusion, bilateral contracts are the cornerstone of contractual relations in Nigeria. Like I said at the beginning, most commercial transactions are hinged and based on bilateral contracts because bilateral contracts have to do with mutual obligations by parties. That is, parties have to mutually agree to enter into legal relations that will govern them and bind them. And so bilateral contracts are key to ensure that commercial transactions go smoothly. Therefore, as I always advise, it is always important for you to ensure that you get good legal representation before entering into contracts. No matter the nature of the contract, no matter the type of contract, always ensure that you have good legal representation, which we provide before you enter into contracts. Again, for a fuller comprehension of this topic, kindly refer to the video that I made earlier on contracts. I hope you got value from this video. Kindly make your comments in the comment section below. Let us interact and share more ideas. Also, please do well to like this video and subscribe to the channel so that you get more updates as we upload more videos. I'll see you in my next video. Bye.